are discussing these things as if they are one issue. They are, in fact, two issues. One is that we want to make sure that in a Commonwealth of 1,050, probably at this point approaching 1,100 prosecutors, that we offer opportunities for training, for being trainers to younger prosecutors, and that we not over-rely on prosecutors who have been out of circulation for multiple years. That was the apple. The orange that was, at least in my mind, and perhaps in the minds of other folks, was the particular issue of Phil Evans. Now, had the general issue been resolved in a certain way, either in May or in August, that would be mooted. If, for example, there had been a hard cutoff in the proposition that that CASC adopted in August, which included a 3-year cutoff, but with an exception that was large enough that it could be applied to just about anything. I did not speak. I am not on council. I am on board. And it was the will of the body to adopt that general proposition. I had gotten some feedback from people who were in this room in the May meeting regarding what the general conversation was. I would like to correct some of the procedural history of how we are here. I am not the one who wanted to have a very public discussion about this. And forgive if I'm raising my voice, I want to make sure the people in the electrons can hear me. I did not docket this. I, in fact, tried multiple times to have this handled quietly. I was under the impression that everybody understood what this issue was. And that Jane was aware of what these problems were. My inquiry to Jane, and Jane, you're here, so I will talk to you. Nobody talked to me directly while we were discussing this. I was referred to in the passive voice. I emailed you because I wanted to know who the faculty list was. You were kind enough to provide me with a prompt response. I appreciate that. It is your discretion to choose who your faculty are, absent a vote to the contrary from CASC. That's your prerogative. My inquiry, based on the fact that Brian's motion was adopted nearly unanimously in August, was whether you had decided whether Phil would return. I essentially got no answer from you. You didn't give me a straight answer. That is why I sent the email and asked for the names of the other prosecutors. That information is subject to FOIA. I can also just get it by emailing the 120. I can reach everybody by definition by emailing the 120, as I eventually did. My interest was this, and David, I appreciate your point about notice and defense, but this is the equivalent of having an officer on the Brady list courtesy of the federal court. We may think the officer's a great guy. Personally, I think when the Fourth Circuit says something and I disagree with it, I by definition am wrong. However, I'm not really in a position to argue that the Fourth Circuit's word carries more weight than mine. So the issue is the same as a Brady listed officer from federal court. It's not whether we agree or disagree. It is whether it has happened. It is the fact that it has happened that is a sufficient, not a necessary ingredient for the conversation. The reason that I wanted to discuss this privately with the other Murder 1 and 2 attendees' bosses and with the bosses of the other